Identifying creditor harassment. Hi, I'm Ryan Singleton. I'm an associate attorney with Holland Law Group. I specialize in debt defense and creditor harassment. When you hear the words creditor harassment, you may think of a debt collector calling you and using profane language or threats of bodily harm to you or a loved one. And you'd be correct. Such behavior is prohibited by creditor harassment laws like the Fair Debt Collection Act, the FDCPA, and Florida's Consumer Collection Practices Act, the FCCPA. In this video, we are going to explore several common situations where people may not be as clear whether creditor harassment has occurred. Calls to your family members or friends. On November 30th, 2021, a new law named Regulation F went into effect that clarified various aspects of the FDCPA. With respect to calls to family members or friends, Regulation F advised that such calls are permitted for purposes of obtaining contact information of the account holder. However, the debt collectors are not permitted to disclose details of the account. Such behavior can still be considered a violation of the FDCPA. Receiving multiple calls from the same creditor. Regulation F established a limit on the number of times a creditor may call. They cannot place more than 7 calls within a given week, and they are not permitted to call back for a full week after discussing the account with the account holder. At the same time, there's precedent that says a creditor should stop calling altogether if you've spoken with them, or told them that you're unable to pay and asked them to stop calling. Receiving multiple calls from telemarketer or scammers. While you may receive a significant amount of calls from telemarketers or solicitors, such activity is not creditor harassment because they are not creditors attempting to collect a debt. At the same time, there are rules for such callers as well. Like creditors, they should not call before 8 a.m. or 9 p.m. and have to identify who they are and the company they work for. You can go to the National Do Not Call Registry to stop unwanted sales calls by going to the website below. Scammers attempt to commit identity theft by obtaining your bank account numbers or personal information. Oftentimes, scammers are pretending to be debt collectors. To learn more about how to distinguish between a scammer and a real debt collector, read our previous blog, Is This a Scam or Creditor Harassment? To learn more about phone scams in general, please read the article below. Being told that if you don't pay the debt, there could be a judgment entered against you, which may result in garnishment of wages or bank accounts. This may sound like threatening language that you may think should be considered creditor harassment. But if a creditor does have a legitimate right to file a lawsuit against you, then a judgment and/or garnishment could end up being the possible consequences. In such cases, the call would not be considered harassment because the creditor was providing a truthful warning about a possible outcome if the debt is not paid. Receiving a collection letter for a debt that you already paid or settled. The letter was sent around the same time or shortly after the debt was paid or settled, that would not be considered creditor harassment. Even a letter sent 2 to 3 weeks after the fact may not be enough, as creditors can assert a bona fide error as a defense, and part of that can be that they did not have enough reasonable time to process the new information. But after that reasonable period of time has passed, any attempt to collect a debt that has already been paid, settled, or discharged in a bankruptcy would be considered a creditor harassment violation. A debt that you already paid or settled is still showing a balance on your credit report. This could end up being a violation of the Fair Credit Reporting Act, the FCRA. But the first thing you need to do is dispute the error directly with the credit bureaus. You will then receive a response within 30 days of the dispute. If the creditor fixes the error and removes the negative reporting from your credit report, then all is well and there's no violation. But if the creditor verified the outstanding balance is accurate, then it would be an FCRA violation. If you believe you have experienced any form of creditor harassment, do not hesitate to contact the Holland Law Group to hire an experienced Florida attorney. We have attorneys throughout the state that can assist you, whether you're in Miami-Dade, Hillsborough, Duval, Orlando, Sarasota, or any other area in Florida. Call 941-744-5450 for your consultation today.